Ghanatube so it was your wonderful snowy masan so atenasi biom meden sem ahodo etwegum the four corners of Ghana bro na intem pass no senior matenase no meden be kwakotie ensem bia ekoso ewo omani na eba na busanfo matwa so ediamamo.
This afternoon, the Supreme Court has struck out Chief Justice Torkornoo's supplementary affidavit supporting an injunction application seeking to halt her suspension and the impeachment proceedings. The supplementary application filed on May 26 seeks, among other things, a restraining order against the five-member committee from continuing with the removal petition hearing. She also wants two justices of the Supreme Court, Gabriel Scott Praman and Samuel Adibu Asiedu, removed as members of the committee. We'll take you to the court right now this afternoon, where the court has also been having choice words for lead counsels on the side of the state and then the Chief Justice as well on public utterances over the ongoing matter. Let's connect with Dennis Pwaberi Wadam right now and get a bit more from him. Dennis, earlier the court overruled the AG's objection of the inclusion of the five-member committee members as defendants. Tell us a bit more about this.
Inspection, and earlier, like indicated, the AG raised an objection against the inclusion of the five members of the committee looking into the petition against the Chief Justice. The basis for that objection was that when you look at the writ of sermon and some of the statements that were said in there, it makes reference to a specific paragraph that says that the affected person in the suit is going to be the Attorney General. And on that score, it says that what it means is that it's only the Attorney General who is the proper party to the suit, and the other five members who happen to be members of the committee are not proper parties. And to that extent, he told the court to exclude those five members from the suit. However, the former Attorney General, who happens to be the lawyer for the plaintiff applicant in this particular matter, the suspended Chief Justice, made the argument that no, the law is not just about who is going to be affected, but also has to be whether or not some reliefs or claims have been made against certain persons. And that when you look at the writ of sermon, you will find that as many as 6 claims or reliefs have been made against the 5 other members who happen to be the second, third, fourth, and fifth and sixth defendants in that particular suit.
Right.
So the court had to decide on that matter, and that was dismissed.
And we know as well from reports coming from the court has struck out that supplementary affidavit as well. That was the affidavit which detailed the Chief Justice's description of trauma and the likes. What was the basis upon which the justices of the court arrived at the decision to strike that out?
Precisely so. So the Attorney General, also in court is the Deputy Attorney General who is representing the Attorney General's department in this. He made the forceful argument for the exclusion of that particular supplementary affidavit. In other words, a sworn statement of fact that the Chief Justice had made to some happenings that had happened subsequent to the filing of the suit. And those happenings were largely things that happened before the committee hearing the petition. Like rightly indicated, there are matters that had to do with whether or not her lawyer was given prior notice and how hearing dates were changed without notice to the lawyer, how she was searched, and even how some of the petitioners were not allowed to give evidence in person. So the matter that came before the court was the question of whether or not these were matters that were before the committee for which they should be protected under Article 146A, which requires that such hearings must be in camera. That was basically the argument of the Attorney General, or Deputy Attorney General, as he advanced in court, that those depositions as contained in that supplementary affidavit were entirely covered under Article 146E, that they should be in camera, and to that extent, they should not be made public. However, that was opposed by the former Attorney General, Godfred 亚hocking, who makes the case that there have been judicial pronouncements that clearly define what amounts to proceedings. And for him, he does not think that what was contained in that affidavit amounted to proceedings. he actually stated that when you look at the affidavit, the supplementary affidavit, from paragraphs 1 to 6, were not matters that can be called proceedings. So he made reference to certain provisions of the Constitution that well as the cases of Peter Jerry and Tiger PI, also making a reference to the very famous case of Ŵrrrcwm and the like, to make the case that a distinction has to be drawn as to what constitutes proceedings and what does not. However, there was an interesting development when the bench decided to engage in a bit more
on the arguments he was making.
Exactly. And it came to light that yes, indeed, the matters that were being talked about were matters that had come before the committee for hearing, and the bench again went on recess and had to take a decision on that. And the ruling of the court was that they come to the conclusion that when you look at what contained in that affidavit, it is clear that everything that was said in there were matters that were before the committee, and as such, they need to be protected by Article 146(8) of the 1992 Constitution. They need to be in camera for that matter. That supplementary affidavit should be struck out. Indeed, they did indicate that it was possible for the Attorney General to actually prosecute his case based on the main affidavit without the addition of that supplementary affidavit. So on that score, that was struck out.
And we know that the injunction hearing as well is supposed to take place. These are what some will call initial arguments that's come forth before the court. What about the injunction which the Chief Justice is seeking, restraining the committee from proceeding with the hearing until the final determination of her case?
So that's what's being heard now. So a while ago, the former Attorney General, Ạ, who represents the plaintiff applicant, was on his feet to advance his case for the grant of that particular injunction application. He had started by making the case that yes, there's a serious matter to be tried, which is largely a requirement that needs to be met for the grant of such an application. And the basis for that was to the effect that when you look at the determination of the former Fashion case, it is the argument of Governor Ạ that his client, who is the Chief Justice, was not given that a copy of that determination. He makes reference to a correspondence between the presidency and the suspended Chief Justice, a letter that was written to her indicating that yes, a former Fashion case has been determined or has made against her. He makes the case that she did not get a copy of that. So she's even unaware the kind of allegations that have been leveled against her and on what basis that former Fashion case had been established. Based on that, he says, if she's not been given a copy of that determination, then it means that her right to fair trial has been undermined. He also added that it is unconstitutional for that to have happened. But you recall that the Attorney General in his affidavit in opposition did argue that they are giving copies to all people who are considered mandated to have copies of that information without saying more. To Ạ, he says that that was a chilling argument to hear from the Attorney General, because he says that the Attorney General is supposed to be the foremost person who is supposed to protect the Constitution as well as the rights of all individuals in this country. And to make that argument for him, he found it a bit strange that the Attorney General was making an argument in that light. Dennis, I want to leave you so that you can return to the court and then you get details of the AG's arguments, the Deputy Attorney General's argument as well, and then subsequently we can get details as to the final determination on that injunction application. But Dennis Wedam is my colleague at the Supreme Court for us, and I'm certain in the course of this bulletin we will connect with him again to get details of exactly what's happening. But we know that the Supreme Court, the justices of the Supreme Court, they struck out the supplementary affidavit, details of which we brought you yesterday, where the Chief Justice, amongst many other things, made the argument that her phones were being searched, she was being searched, and she wasn't allowed to go into the committee hearings with her phones, and then same for her lawyers, her family,
immediate family as well not being allowed access to the committee hearing, and questioning why the hearing was happening around the Osu Castle and mental torture amongst many other things. That has been struck out. The injunction application by the Chief Justice is currently being heard, and we'll take you there for details subsequently. But
for comment, comment section. I'm I can kindly na ediamo. Answer na meso musu me ka musu aha Ghanatube so. In same bia ekoso ewo online no onsa ebeka. Subscribe na hit the notification bell no for quick updates. See you there. Macau.